right, we will now move on to the Court of Criminal Appeals. And Jordan, you're still there, and I'll call up Presiding Judge David Schenck and Judge David Newell, Chair of the Judicial and Court Personnel Training Fund.
Madam Chair, Senators, thank you so much for having us here today. I am Presiding Judge David Schenck. I am 4 days senior to Chief Justice Blacklock, having been on the court now for 25 days. It is a privilege to be here with you and a pleasure. With me today is Judge David Newell, who's been with the court for quite a long time. Our intention today is to speak to you about the exceptional items we've requested. I would focus on the exceptional items dealing with specifically with the court's own administration, and Judge Newell, who has been overseeing our grants, will talk to you about the important grant recipients we have and the extraordinary items we've made with respect to them. Let me begin by thanking the Senator Huffman and your committee for the existing funding provided in the introduced bill. We appreciate that, and also wanted to thank you for your attention to these matters. And before I get on to these exceptional items, I can't help but go back to the testimony we just had with the Chief Justice, my comrade. As you know, for those who don't, Texas is one of 2 states that have 2 functionally Supreme Courts. We have a high court for civil matters that we call the Texas Supreme Court, and for criminal matters, it's the Court of Criminal Appeals. I chaired the State Commission on Judicial Conduct for several years and was justice on the 5th Court of Appeals. I'd be happy to engage with you on some of these questions about judicial accountability, but I want to begin with my complete agreement with Chief Justice now Blacklock on judicial pay. I would add that according to my friend Google, who I consulted a few minutes ago, the salary for a U.S. magistrate judge this year will be $247,000. That'll be more than $50,000 more than our highest judges are paid in the state, and that magistrate judge is not allowed to try a slip and fall in a grocery store without the explicit consent of both parties because they're too low in the system. We need to attract good people. We need to retain good people. And the challenge that I've seen while I was chairing that conduct commission and while I was serving as an appellate judge in other capacities is we can't make them grow taller. We can't make them get smarter. And if we sometimes you get what you pay for. And I completely agree with the chair's statement some minutes ago that accountability has to run together with these pay raises. These things, they do run together. But I think with the leadership that you're showing here, I think that we're going to make progress here. And I hope we can make progress with the Conduct Commission. I will support you in those efforts. Senator Jafferini, I know while I was chair, you made important contributions to that commission, and I think there's a lot more work to be done there. But I'll just get into the specifics. With respect to your concern about tracking judicial performance, particularly in the trial courts, this body, this legislature, created an entity called the Court of Special Review, which is made up of judges who are appointed by the Chief Justice of the Texas Supreme Court, who do not sit together normally, and from whom there is no review of their decisions. So sitting as chair of the Conduct Commission is somewhat frustrating, or it was somewhat frustrating, when the Conduct Commission, for instance, would enforce the existing canons. I don't think we need additional legislation on this. There are canons of conduct that require every judge to treat their judicial duties as their primary obligation. There's another canon that says that you must conduct your judicial business promptly. The Conduct Commission sanctioned judges for not doing their work, for not ruling on matters for more than a year. The Conduct Commission's decision was subject to review by this Court of Special Review, from which there is no further review, and they said that we cannot sanction judges unless we can prove that they were specifically aware of the matters that they were supposed to handle and didn't do it. So there's no place else for us to go. That that's Court of Special Review is a matter that I think could be under review here. It's not authorized specifically by the Constitution, and as I say, it's made up of appointed judges that were not elected by anyone and from whom the Conduct Commission's in no position to get reviewed. But I think that these pay raises are important, but I think the accountability goes with it, and I think we have existing canons in place. And I would support, and I'm sure Chief Justice Blacklock would support anything that you can help us to do to enforce those canons. But having chaired that commission and having seen the difficulties in getting that commission to move as it should and to take on the cases, that it's a little frustrating when we go out and we try to deal with these problems and we find that we're at an impasse. So I hope with your help with respect to the legislation, with respect to the Conduct Commission, we can address those concerns. Now, with respect to the specific, and I'm sorry to be bringing up tens of thousands, we've talked about billions of dollars here, but we have a criminal justice system that we preside over that requires some funding, and we have some very simple matters that I hope with your help we can address. We have an extraordinary request for $48,000 to pay the Office of Court Administration to record our oral arguments. That's an internal one pocket to another transfer of funds. We do hear oral arguments, and the public sometimes likes to listen to them. And by contract, we have to pay the Office of Court Administration to record those. That was not funded, and we need $48,000 for the public to be able to hear those oral arguments. Separately, the court physically has not been addressed since the 1980s. The carpets are that old, the building is that old. I would like to do some upgrades to the physical facilities. We're asking only for $200,000 for that. Likewise, there's an extraordinary item requested with respect to travel for court staff. In 2016, the voters amended the Constitution to remove the requirement that statewide office holders live and reside in Travis County. We did not want only Austin-based people serving on these courts, and we have, this body again has passed legislation, HB 3474, now Government Code Section 223015, providing that there'd be reimbursement for travel for court hearings, but you have not funded it. So right now, the judges themselves are paying out of pocket to travel for court hearings. And on top of everything else that we've been hearing about, we would like for you to consider that as a relatively small item, $108,000. That's $1,000 per month per judge to attend what is now 4 conferences per month in person in Austin. I have been paying myself out of pocket for the hotel bills to come down here and attend court. Lastly, and this is, I think, an important matter that gets to the heart of some of what you were addressing with Chief Justice Blacklock. I believe my court is going to need some rules reforms. And if you were paying attention to the campaign I ran for this office, I will remind you, if you haven't heard it already, about some of the concerns I have with respect to productivity. And some of it is not owing to the court's activities, but owing to population growth and increase in cases. But we are now disposing on this court of 6,000 cases a year. That's 6,000 divided by 9 judges. I think we're going to need some rules reforms to have fewer eyes on more cases and more close attention and more prompt attention paid to major cases. Those rules reforms are going to come. That's one of the requests I have for a FTE is for a staff attorney, a rules attorney to work with me to reform the way the court is currently operating. But right now, in capital cases, we are taking on average 628 days from filing of the notice of appeal to the disposition of the matter. That is too long. For cases that are granted on direct review from lower courts, the courts of appeals, in 2014, it was taking us 193 days on average to get a final decision out to the public about what the criminal law of the state was. That is now swelled in 2024 to 504 days. That's approaching 2 years to get a decision, and that is too long. I'm asking for 2 FTEs to work with me to focus on those dockets, to make those rules changes and start getting these cases out more promptly. And I think these are fairly simple requests. I think they go directly towards some of the concerns that you have, and I want to deal with those on our high court immediately. And as I mentioned before, I'm more than happy to work with you, and I know Chief Justice Blacklock is more than happy to work with you to increase the public's confidence and the competence and the efficiency of the courts that they're paying for, and they have the right to expect that. And we are committed, along with, I'm sure, Chief Justice Blacklock, in doing everything we can to give you all the assurances that you could possibly ask for, that every judge we have in every seat in the state of Texas is competent, fair, and efficient. And with the whatever reforms you think are appropriate to the Conduct Commission, I would hope that we could get there. Now, with that, I'll turn over, if I might, to Judge Newell, who will talk to you about the very important grants requests we have.
First, let me check, see if there are any questions, Judge. Are there any questions, members? I think you'll find most of us are always willing to work with the judiciary on any issues that arise. But there are no questions.